So, welcome everybody. I'm delighted that you have joined us. It gives me great pleasure to introduce to you Britt Morrow from the Blockchain Intelligence Group. For those of you, I should say, who don't know me, my name is Roger Isaacs. I'm a partner at Milstead Langdon, and I specialize in expert witness work and forensic accounting. And in that capacity, I'm often asked about the blockchain and about Bitcoin. And unfortunately, I have to admit my complete ignorance on the subject, which is why I was delighted to come across Britt and her colleagues, because they are able to do what I am not in a manner that she much more eloquently than I will describe over the course of the next few minutes. So I shall let Britt introduce herself, but broadly what she will help you to do is to understand, firstly, how if you've got clients who have got Bitcoin or other cryptocurrencies, she's able to help check that what you're being told in the context of a divorce or any litigation really is right. And secondly, that for those of you who are real, as they say in the West Country, real keeners, very, very interested in Bitcoin, how she can actually help you use the software that the Blockchain Intelligence Group produces to do some of this work yourself. So without further ado, let me hand over to you, Britt.
Fantastic. Thank you so much, Roger. And thanks again for inviting me here today. So like Roger said, my name is Britt Morrow. I work with Blockchain Intelligence Group. We're based in Vancouver, Canada, and we have offices in the United States as well as a team worldwide as well. We're publicly traded in the US and Canada, and we have a long history of working with law enforcement, including big government agencies, police departments, worldwide. We also work with fintech exchanges, businesses, really anyone that accepts crypto as payment. But more recently, we've had a large number of interest from lawyers, forensic accountants, even individual investors who have been scammed or duped out of cryptocurrency and want to have some visibility into that. So before I dive a bit into blockchain and cryptocurrency and what that means, just to give you an idea, to put some context into this for you, we have a forensic division and we have a large number of attorneys or people that come to us that have had crypto assets stolen or scammed, or in a divorce case, if one party is suspected of concealing assets. So most recently, we had someone come to us and say, in a divorce process, they disclosed that yes, at one point they had crypto assets, but they sold them and cashed out. And, here they disclosed their address. And then the balance of that address was nothing. It was zero. So they had their story. However, the opposing counsel thought that that was a little bit suspicious and wanted to dig into that to verify, that in fact the balance was zero. So we were able to look into it and see that they'd actually transferred a large number of money, thinking that they were being really crafty in doing that, to another account to hide it. But in fact, we were able to see. So at that point, they were able to go back and ask a number of questions and just continue that conversation there. So blockchain and cryptocurrency basics. You can think of blockchain as a database or a network. So as opposed to a normal computer database, which might be stored in one location, the blockchain database is located on a number of computers located all over the world. And all of these computers work together and they come to agreement on transactions that are added to the database. So what this means is that the transactions that are added to it can never be changed or modified or manipulated. So all transactions that go on the blockchain are a public record. So cryptocurrency comes into the picture because it's the digital currency that uses the blockchain. So it facilitates the transactions. It's how information and transactions are stored on the blockchain or database. So you've probably heard of Bitcoin. Bitcoin is the name of the cryptocurrency, which also runs on the Bitcoin blockchain or database. There's also Ethereum, Dogecoin, Cardano, and thousands of others that you may have heard of. But we find the majority of cases, especially in hidden assets or in a divorce case, are the big ones like Bitcoin and Ethereum. So cryptocurrency, you might have heard that it's anonymous. That's sort of true, sort of not. Cryptocurrency is actually pseudo-anonymous. So what that means is a crypto address, it looks like a number of letters and numbers together. So similar to a check where you have the account information and the bank information here, an address is similar. However, on the check, you can see the name belongs to John Smith. And if the name John Smith wasn't here, you wouldn't know who this account belonged to. So it's the same with crypto. You don't know who the address actually belongs to unless someone tells you, or you're able to go to an exchange or somewhere that collects that know your customer identifying information. So what the blockchain actually looks like. Like I said, there's a number of, it's public information, and all transactions are recorded on the blockchain. So you can go to blockchain.com, for example, which is a public block explorer, and it looks something like this on the left hand of my screen. So these are all addresses, and it's showing a date and time and the value of Bitcoin in this case that has been sent. So this is, pretty difficult to follow, very manual to do. It is possible, but it can take months and a huge amount of effort to follow what this looks like. So in your case, if you were working and asking a party to disclose their crypto address, it would be something like this, one of these. So this is what blockchain data looks like. However, our tools called Clue take this blockchain data and reposition it into a visual format that's really easy for you to see and follow the transactions. So I'll just show you what this looks like. So I've just hopped in our Clue tool now. So let's say this person here gave you, sorry, one second here. My apologies. Okay, let's say that a customer came to you and gave you an address. You'll recall from the previous slide, they look something like this. So this address. So we plunk it in the system, and we're able to get a visual representation of that address and see all the transactions that have transpired from that address that have been sent or received to it. So this is a fraud case, for example, but this is really similar behavior to a hidden assets case and what you might typically see in a divorce case. So this person here had 14.51 Bitcoin stolen via this transaction. So this is how we label the transaction date and time. And then it was sent to this address. So this is really common. They'll have one address and then send it to another. And then this person continued to send these funds around. So they'll keep making addresses and shuffle the funds between them. They think they're being really crafty and you're not going to be able to follow it, but we actually can see everything that they're doing. So here they had this transaction. They sent some to this address and some to this address. Then our tools allow you to just keep following the Bitcoin here. So we have another transaction, came down here, 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 and eventually ended in this Binance, which is an exchange deposit address. Now, if we go back, we can see that they did the same thing, again, thinking they're being very clever, creating these different addresses, shuffling these funds between them, and eventually it ends up in the exact same Binance exchange deposit address. So in this case, at this point, you'd be able to go to Binance or whatever exchange it might be and collect the customer identifying information for this address. And then you're able to see that they've moved funds to an exchange. Alternatively, let's say your original person here, this is your address in question. And if they had said, oh no, the balance of the account is zero, we can still see that the balance of the account might be zero, but at one point they had sent 14.51 Bitcoin, which is a substantial amount of money, to another address in the past. So it just gives us a lot of visibility into all blockchain activity.
And is all that information public?
Yes, this information is all public in the blockchain Explorer, which I showed you on a previous slide here. So all of this information that I just showed you is public here, and it looks like this. So we have taken this information and put it in this visual format so that you can follow it very clearly and see what has transpired. Otherwise, you'd be following these, which is, you know, quite difficult, as you can imagine.
So all you need for that analysis, apart from your clever software, is what? Just the initial number on a bank statement or a credit card statement?
Absolutely. So I'll dive right into that. So what does this mean for you? So it's important to collect any relevant information from the opposing party. The slam dunk would be if you ask for a crypto address, if they've ever held any crypto assets in the past, currently have been involved at all. If you ask them for their crypto address or addresses, there might be more than one. It would be ideal if they're very forthcoming and give this to you, and then it's a very easy starting point from using our tools to be able to see what has happened and get a big picture there. However, if they aren't as forthcoming with their address, there are some things you can do. One of them is look into bank and credit card statements, in particular looking for deposits into crypto exchanges. This is a really good clue. There also might be crypto accessories that they buy. An example of this would be a hardware wallet, which is like a USB stick where you can store your crypto codes. So crypto accessories, internet browser history, if you have, access to that, can give clues as well. But the number one great thing is to have them disclose the address or addresses to you, past or present, even if they're not active anymore, as well as going through bank and credit card statements. If you're interested in learning more about crypto, we do have a certified cryptocurrency investigator course. It's very beginner friendly. It does a really great job of teaching you about blockchain basics, cryptocurrency, the dark web, how all of these words you might have heard before, they all work together, and how to actually go about investigating or tracing crimes, including hidden funds. So we work with a number of lawyers who do work in divorces, but also have positioned themselves as specialists in crypto scam asset tracing, just using our tools. So this course is very beginner friendly. It's a great place to start. There's no big scary test at the end or anything like that. There's little quizzes as you go through, but it's very worthwhile if you are interested in learning more. There's a few ways to work with us. Training, I already mentioned, our certified cryptocurrency investigator course. We do have forensic services. So that means we're able to do this work for you and bill at an hourly rate. The rate is $275 per hour. And in that case, we would need information from you like addresses or bank statements or really any information, and then we could go in our tools and build out a case for you and export a nice graph and put it together in a report. Alternatively, we have a subscription to our software called Clue. It's billed monthly. There's no annual contract. It's been designed to be very user-friendly. So even if you don't know anything about crypto or you're very new to it, once you understand a few basics, it's really quite straightforward, and you can use this and do this yourself quite easily. And if you do choose to go this route, we include comprehensive training and ongoing support. So that means right when you sign up with us, you'll be assigned a designated customer success manager. This person will hop on a call with you right away, do a screen share, provide you with full training so you're comfortable using our tools. And then down the road, if you're working on a case, you have questions, you want to be pointed in the right direction, we'll always hop back on a call with you and help you out. Our goal is for you to be very proficient and comfortable using these tools. Clue is $599 per month, again, it's just on a monthly basis. There's no contract at all there.
And if you had, say, a spouse who said, I'm worried that my partner's hidden or not declared cryptocurrencies, and all I found is this old bank statement, and there's a reference number that I don't really understand, and that's all I've got. Would that be A, sufficient for you to work on it, and B, what sort of cost would that be in terms of number of hours if somebody wanted to hire you?
Yeah, it depends on, you know, the information that they give us. Again, if it's an address, a crypto address, that's the ideal place for us to start. If it's a deposit into a bank statement that shows a deposit into an exchange, then there's more questions that need to be asked at that point, because we can't really start until we have an address. You might have to go through an exchange to get that through whichever legal process is available to you. It's difficult to say how many hours it might take, because there's just so many variables in each case. So it's so challenging. It might be like 3 to 10, or it might be 25, depending on the complexity of it. Usually the hidden assets cases are a bit more straightforward than the stolen funds cases, where there's an elaborate fraud scheme or ransomware involved. Those take quite a bit longer. But typically these hidden asset cases, the users aren't particularly sophisticated. They just think that they're, you know, being crafty and moving the funds around, and we can usually get full visibility into their behavior or what has transpired very quickly in not as many hours. So I hope that helps or answers your question.
That's really good.
Yeah, and again, you can see this all yourself using Clue, and we can teach you how to do that so that you can differentiate yourself as a crypto or someone that can specialize in that as well. We get so many inquiries about this. The market is just huge, and not a lot of people are specializing in this yet. So that's it. So we covered a lot at a very high level. If you have any questions after this,
we've got one already that's come in. So
oh, okay.
I can ask you this. So I'll read it to you. Is it correct you cannot trace crypto assets through an exchange where the wallet owner has converted it to another cryptocurrency without the exchange providing the onward exchange or transfer info, which it won't do without a court order? Did that make sense?
Sorry, I'm just reading it here. Is it correct?
Yeah. Let you read it yourself.
So it's tricky to answer. We do have in our tool, we do have multi-chain analysis. So if you have the address of one person, you can also say it's a Bitcoin address, but you also suspect them of having ETH as well, or they make a transfer, Ethereum rather. You can build those together, put those together in our tool and build out a profile of that, but it is a bit complicated and might vary by the exchange. I'm not sure how it would work in particular in the UK, but there's kind of different rules all over the world for how these things work. So it's tricky, but we can talk about this in a bit more detail after the call if you like, Matthew.
Great. Well, look, let me, that was really, really helpful, and lots of food for thought. And clearly people can either continue to post questions and we'll come back to them at the end. And in fact, we've had another one which we can answer now from Alison Horse. How does a non-fungible token on a digital artwork in terms of tracing sale or transfer work? Is it similar to blockchain?
Yeah, it would be, so non-fungible tokens, NFTs, it would be very similar. It just depends which blockchain it's hosted on. And it depends on if the software supports that blockchain or not. But it would be, overall, yes, it's the same idea. Great.
Well, and I was amused that Banksy, the graffiti artist, apparently did a piece of artwork which said, why do you idiots pay so much for this rubbish, or something he drew, and then he set fire to it, and then he videoed the fire and created a non-fungible token for the video and sold the video for a fortune. So great
It's
reflection.
a whole new world.
It is. I find non-fungible tokens even more confusing than Bitcoin and so on. So I would encourage everybody to continue posting questions. If you can stop screen sharing,
Sure.
we will move on to the second part of the talk, which is something, as they say, announced something completely different, which is that I'm going to say a few words about historical valuations in divorces, which has once again become fairly topical thanks to a recent case about which I shall talk. So hopefully, can everybody, Britt, can you see my screen? Excellent. Good. So historical valuations. Now, most of those on this call will know that historical valuations have become relevant in divorce cases because a spouse after a long marriage is typically entitled to 50% of the assets of the marriage. Those assets, including not the value of a family business at the date of the divorce or the date of the trial, but the amount by which that value increased during the course of the marriage. And therefore, one has to give some thought not only to the value of the business at the date of trial or the date of divorce, but also to the value of the business at the outset of the relationship. And most of you will be very familiar with the Jones and Jones case, which came up with the concept of a springboard. And just by way of a brief reminder, what happened in that case was that the value at the date of trial was deemed to be £16 million. That's the value of the business. And the two experts, the expert for the wife and the expert for the husband, both agreed that the value of the business at the date of the marriage had been £2 million. So one might think that the increase during the marriage, you don't need to be a forensic accountant to work this out, was £14 million, and therefore it wasn't unreasonable for the wife to have submitted a claim in the proceedings for £7 million. However, the judge decided that £7 million was the wrong answer. And he therefore had to come up with a mechanism to deliver the right answer. And the issue that arose and that became clear in that case is that what forensic accountants are doing is assessing the price that a hypothetical purchaser would have paid to acquire the company at the valuation date. And you would think that that would be a fairly straightforward thing to be agreed by all parties. And of course, in this case, the answer was uncontrovertibly £2 million. So how on earth could there be any argument about that? Well, the answer is that actually that's the wrong question. The question that the courts are trying to answer is, what is the value that should be ascribed to the company at the date of the marriage in order to achieve a fair value in the context of the proceedings? And that, of course, is an entirely different question. And the question, therefore, arises, how do you answer that question? Well, the judge in the Jones and Jones case came up with a concept that is a complete anathema, not only to me, to most business valuers, but to most of the thousands of clients that my firm has, all of whom work very hard in their businesses. And if I were to suggest to them that their businesses grow in any sense passively, they would be utterly outraged. But no, the judge decided that there was this thing called passive growth, which he applied in the Jones and Jones case based on the oil and gas share index, because that was the sector in which the particular company in question operated. And he said that therefore the value of the business, although 2 million had been the figure agreed by the two forensic accountants, should be doubled for passive growth, which reflected the growth in that index, to £4 million. Unfortunately, £4 million was still the wrong answer. That didn't give the wife what the wife needed, or the husband what the husband needed. So therefore, the judge had to think again and came up with another new and novel idea, namely the springboard, the latent potential of a business to achieve what it subsequently did. And the thing about the springboard is it is once again an anathema to business valuers, because the £2 million valuation that the two forensic accountants in the Jones and Jones case had come up with should have taken into account the latent potential because the price that a purchaser will pay for a business reflects its potential for growth and also the risk that it might not achieve that growth. So that was already built into the £2 million figure. So what was it that the springboard was doing? The answer is it was simply a mechanism to come up with what the judge considered was the right answer. So what then happened was you had the value of the business that had been agreed, as I'd said before several times, at £2 million, and then it was doubled for passive growth to £4 million and doubled for the springboard to £8 million. Well, again, without being a forensic accountant, the maths is not that hard. If you have a value at the date of trial of 16 million and the value at the date of the marriage is 8 million, now the increase during the marriage is only £8 million, and that would suggest the wife would get only 4 million. Well, you'll be pleased to know that the judge decided in that case was the right answer. And therefore, that was the basis on which the award was made. In the recent case in which I was giving evidence, Mostyn said the doubling of the initial figure of £2 million to £4 million seems to be based more on instinctive feelings of fairness rather than being referable to any particular piece of evidence. And I think that is absolutely right. And that's why I wanted to give this talk and reflect on this issue, because it does seem to me that for practitioners, it poses a particularly difficult question, not least whether you need historical valuations at all, because if this isn't about forensic accounting, but feelings of fairness, well, the last person you'd ask about feelings of fairness is an accountant, for goodness sake. So are we the right people to be consulted about this? Another approach which has been taken by the courts, which is worth reflecting on for a moment, is the so-called linear approach. And that approach was adopted in the case of WM and HM. Now, in that case, huge company, it was worth at the date of trial £220 million. And there the judge said, well, I'm just going to take a linear approach. It was clearly worth nothing when it was incorporated. And the couple got married 20% through its life. So I'm going to say that effectively 20% through its life, it was worth 20% of the ultimate value. And therefore the increase in value during the course of the marriage was 80%. Again, you don't need to be a forensic accountant to do that level of maths. And it's a straightforward approach, and of course bears no relation to what actually happens in most companies, which is that their fortunes rise and fall through economic cycles and changes of management and all sorts of reasons, which means that at any one point the value can be particularly high or particularly low, which was in fact the case in EVL, which was the case in which I gave evidence. And I gave evidence not on my own, but as this slide is intended to represent, thanks to the rather splendid photoshopping, in the hot tub. For those of you who don't know what hottubbing is, it's the colloquial name for witness conferencing, whereby a number of experts are sworn in together and ask questions in a rather French inquisitorial approach. It bears little relation to English adversarial cross-examination. And the experts are sworn in together and quizzed by the judge, in this case, Mostyn. And it's worth reflecting that one of the unusual features of this case was that there was a Daniels and Walker application by the husband, who took great exception to my report. I was the SJE. And my experience recently has been that it's very difficult to get Daniels and Walker applications through, but Mostyn said not only was he willing to allow the husband permission to adduce evidence from his own forensic accountant, but, quote, in order to allow for equality of arms, the wife should be allowed her own expert too. So there were three of us, which I think is probably why Mostyn decided to use this hottubbing approach, because clearly 3 days of accountancy cross-examination one after another is something that no sane judge would want to submit to. And hottubbing gets through the whole process an awful lot quicker. So there were three of us. I was the SJE. The accountant appointed for the wife was largely agreed with me on all the substantive points. And where we both took issue was with the valuation of the business, specifically at the date of the marriage. And this was a case, I mean, it was quite a fraught case. The couple couldn't agree on anything. They couldn't even agree on how long they'd been married. I mean, I was thinking of it as the Friends argument, for those of you who've seen the series Friends, because the husband argued that for most of the marriage they'd been on a break, and therefore that shouldn't count towards the total length of the marriage. Well, that didn't really affect the business valuation aspects of the case. But in that context, what Mostyn said was that it is an iron principle of pure valuation theory that when advancing a historic valuation of an item, the valuer has to be transported back in time to the date of that valuation and must formulate his or her opinion using only the data available at that time. The valuer is not allowed to use actual knowledge of subsequent events to influence, let alone determine, the historic valuation being undertaken. And indeed, that is absolutely correct. When no business valuer ever uses the benefit of hindsight. In fact, in any other area of law outside family law, it would be utterly unheard of. In an unfair prejudice case or a shareholder dispute, you never use hindsight. However, as you'll see, he went on, in contrast, in financial remedy cases, actual knowledge of subsequent events is generally used in order to fix a historic value of the asset in question, and this is regarded by valuation purists as little short of heresy. Well, absolutely that is the case. It is, in my view, heresy. And the way you square the circle as to how you can apply a heretical approach is that it is only heresy in the context of answering that first question to which I referred. The first question was, what is the price that a hypothetical purchaser would pay at the relevant date to acquire the business, knowing what was known at that time? Whereas, of course, the question that the courts are trying to answer is what value should be attributed to the business at the valuation date to give a fair result to the husband or the wife and the parties. And of course, that is a different question. And it was an odd case because I went into the witness box, or the hot tub, supremely confident. And of course, confidence comes before a fall. But I was supremely confident that my approach would be correct because what I and the wife's expert had done in this case is to look at the profits of the business. And as you can see in this graph, they fluctuated significantly, but up to the date of the marriage, which was in 2016, they had been on a downward slide. So I took an averaging approach, but basically both I and the accountant for the wife looked at the profits up to 2016. And in fact, we took an average based on the profits in 2013, 2014, 2015, and 2016. And we left out of account, of course, the profits for 2017, 18, 19, because a hypothetical purchaser in 2016 would have no idea what those profits might be. But just like in Jones and Jones, Mostyn formed the view that if you took that approach, it gave you the wrong answer. And the husband's accountant took a heretical approach that I thought the court was going to throw out. How wrong was I? And that approach was to take an average of the profits for 2013, 2014, 2015, 2016, 2017, 18, and 19, i.e. to use the benefit of hindsight. And by using that approach, you obviously end up with an entirely different valuation, which in this case, Mostyn decided was the way that one needed to get the right answer. So that brings us really to this question: do you need historical valuations? And I think clearly the received wisdom until recently has been that if you're going to do a springboard calculation, you probably do, because of course in Jones and Jones, the starting point was the £2 million. Now, I accept that doesn't really matter whether you start at 2 million, because if you then add an adjustment, which is based on an instinctive feeling of fairness, does it really matter how objective, how learned, how correct from an accountancy perspective your starting point is, if you're going to fudge it to get the number you want in any event? And I think there is an argument to say that even on the Jones and Jones approach, perhaps a historical valuation is unnecessary. But equally, I think that in our adversarial system, it is quite dangerous simply to blithely say to your clients, don't worry, especially if it's a substantial size of business, we don't need a valuation at the date of the marriage, not least because until you know what that value is, you don't know what sort of arguments you can deploy. And of course, when these cases get to court, you are at the behest of the judges, and it's very difficult. They have huge discretion. They now have a number of different approaches that have been used, any of which they can use. Mostyn described the springboard and Jones and Jones as being not a tram track, but a guideline, implying that it was an option that could be used, but certainly one could take a different approach, as indeed he did do. Of course, if you adopt the linear approach, you certainly don't need a historical valuation because you just time apportion the value. But again, even in those cases, for the purposes of negotiation, for the purposes of understanding how strong your client's position is, I suspect you might want to know whether you have got a company that has genuinely grown in a fairly linear way, or whether there have been periods in its time when it was doing less well. So one can imagine, for example, a company that had been in existence for 20 years at the date of the divorce, and 10 years in, it was on the brink of insolvency. And if the marriage happened to be at around that time, let's say it was the time of the financial collapse, you might want to argue strongly that actually it's a nonsense to use the linear approach, and that at the time nobody would have bought the company and it was worthless. And then I can only say that you are in uncharted waters in terms of what a judge might ultimately do, because of course the judge might say, well, yes, okay, the accountants have assessed the value to be nil, but that is, as I said before, the wrong answer, and it doesn't give a fair result, so I'm going to come up with another number that does. And I think that is a real problem for practitioners that these cases have highlighted. And of course, the final thing is, do you ask us accountants now to value businesses using the EVL crystal ball methodology? And I would ask you, as a personal plea, please not to, because I have no idea how this hindsight really works in practice. Because the accountant for the husband in the E&L case, yes, he did use the subsequent profits, but he then did a bit of a fudge himself. And actually, I don't know how much hindsight should affect a historical valuation. So let me put this to you. Suppose you had an asset 3 years ago and you knew with absolute certainty that you could sell it today for £1 million. If I asked you what value that asset had with the benefit of hindsight 3 years ago, surely it must be, by definition, not much short, especially if you don't have huge amounts of inflation, of £1 million. So if you really do value with hindsight, then it's difficult to understand how you ever get any growth in any company ever, if you take the argument to its logical conclusion, and that, it seems to me, can't be right. So I wish I had a way of answering this question, and unfortunately this is one of those talks which it raises a question but doesn't give you an answer, other than to say I think careful thought needs to be given more than ever now to the issue of historical valuations, which are less certain than they have ever been. And I would just suggest that I think it's too soon to say that you don't need them at all, but just to recognize that they're fraught with difficulty. So I hope that has been thought-provoking. We've allowed 20 minutes for questions at the end, but I appreciate it's the end of the day, and you probably, well, the days when we needed to sign letters to get them out is long gone, but I'm sure the emails have been piling up in the background, so I won't be in the least offended if people don't have questions to ask. After the talk, we will, as I put in the chat earlier, be sending out copies of the slides. It does occur to me that certainly I was really grateful to Britt for her talk. I thought it was fascinating, but be really useful, because we're seeing more and more cases where Bitcoin is becoming a feature, And I think it's really interesting, Britt, that you are able to offer both the DIY approach, where you'll do some hand holding, and I suspect there are some firms on this call who might actually want to set up a Bitcoin department, or nominate members of their teams who are interested in Bitcoin and cryptocurrency, who you can handhold and who could actually become experts and helping these cases, because they are becoming ever more common. And I think that's will be a real differentiator for family firms in the future, where they've got that in-house ability, albeit supported by you and your colleagues.
Absolutely. And like I said, once you understand the basics and get acquainted with the software, it really is quite straightforward to use and own yourself. And if you're able to do it that way, you can get in a lot quicker than it would take for, to go through our forensic team. And then you're that much more familiar with it by working through it yourself. So
I should have asked you this before. How long does a typical investigation take if once you've got the information? What are your turnaround times?
It totally depends on what every situation is so different. Like if it's if there's been funds that have gone across the blockchain that have gone to a different address and have gone to a different exchange, and we can assume either cashed out or sitting in an exchange at that point, it's really easy. We can figure that out in a matter of minutes, because it's basically case closed. However, if there's an address and they've moved funds around and they're just sitting in different addresses on the blockchain, on the database, on the network, they're just kind of, floating there, and there's not a whole lot we can do. Maybe we want to monitor them to see if they start to move the funds again, or, so it really depends on what actions the person has taken. It's something that we can see in a matter of minutes, or it might take a bit longer. Again, every case is just so unique.
And do you have experience? So if you have found, and the example that you showed us earlier, it showed a number of Bitcoins ending up in a, I'm going to use the wrong word, account, but it is an account, a wallet.
Yeah, it was a Binance account. Yeah.
With a particular reference number, and you've got no idea whose name that account is registered with. So you then go to the exchange holder, who will say, well, I'm not going to tell you without a court order. What's the? Do you get involved in that process of getting the court order? Presumably, the lawyer just says, look, here is the evidence from the blockchain intelligence group that says that the Bitcoins have moved from A to B. This is the reference number for B. Will you please make an order to disclose?
Yeah, so you would use whichever legal process is available to you to do that. We find that most exchanges are very cooperative in providing this information, because they want to stay, especially if there's any suspicion of illicit activity or stolen or hidden funds or anything that's illegal at all. They're usually very cooperative because they want to stay in the good books of regulators and be compliant. It's in their best interest as well. So for the most part, and all exchanges all around the world there's thousands of them, and some follow the rules, some don't even have the rules that exist yet. But it's becoming increasingly common all over the world to have rules in place that they need to adhere to stay in business as an exchange. So we find that they are more likely to provide you with that information and cooperate.
That's really interesting, because I mean, you ask a bank for information and they'll think of 1,000 reasons why not to provide it. So the fact that the exchanges look for reasons to cooperate is really interesting. It's the last thing I would have been the case.
One other thing I just wanted to mention, going back to Matthew's question earlier, and that has to do with changing the type of currency within an exchange without a court order or with a court order. So just to provide a little bit more context here and how exchanges work versus blockchain activity. So if you have a customer that has an account on an exchange, let's say it's Coinbase or something like that, they have an account, and within their account, they're just buying and selling crypto assets. All of those, whether it's Bitcoin or Ethereum or whatever, all of those transactions are happening within Coinbase's internal ledger, and they're not actually making it onto the blockchain. So in that case, we can't really help you. You would have to go to Coinbase and see and ask them for information, because all transactions are their internal ledger. And you can think of it as like, let's say, Roger, you and I, we use the same bank, and I want to send you $500. So I send you $500, and from the banking administrative side, it's just a note. The funds haven't actually left the bank and gone to a different bank. But let's say there's another person, and they're at a different bank, and I want to send them money. Then the funds are actually leaving the bank, and they're going through the network to a different bank. So that would be the blockchain equivalent of it. So that's where we can really come in and help you. So once the funds, say it's with an exchange, initially, once the funds leave an exchange, there's also a number of different types of crypto addresses or wallet types. So having funds in an exchange is just one example. There's a number of private addresses as well, which occur across the blockchain, which we have the ability to track. So yeah, it's a bit complicated, but once you wrap your head around those concepts, I promise it's not that difficult or overwhelming.
Well, I suspect that in the first instance, most of us will be going for the forensic hand-holding assistance rather than the DIY approach. But who knows? There may be some people on this call who've been inspired to become, with your help, crypto experts. And as I say, I'm sure if they were to do so, it would be a differentiating feature for their firms. And it's interesting you say that a number of firms are already starting to do that and working with you on that basis.
Oh yes, I speak with firms all over the world, so like everywhere, and this is common, especially with in family law, everywhere. So there's a very small number of firms who have tools like this that are able to position themselves as specialists in this, a very small number. But the number of cases where this is becoming commonplace is just massive. So there's huge opportunity here to really, become an expert in this and offer those services.
That's a really positive note on which to end. So thank you very much. Thank you for your time.
Thank you.
We will, as I say, circulate the notes and Britt's contact details. So if people do have questions about Bitcoin or any of the other cryptocurrencies, I'm sure Britt will be happy to hear from you. It goes without saying, if you want some historical valuations, as long as you don't want me to use hindsight, I would be more than happy to do them or talk to you about them. And I wish you all a very pleasant evening. Thanks for attending, and see you all soon. Bye-bye.
Thank you. Bye.